Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, a law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of the podcast.
And that's Mike Levin, an independent activist investor and advisor to investors on activist situations who lives and works in Chicago. He covers the financial side of our podcast.
Yes, and there's a lot to talk about today. I know you and I and many others have spent a lot of time thinking about the kind of place Delaware is for corporations these days, and you've actually written some blog posts on that subject, and a recent significant case would be worth exploring in today's podcast.
Yeah, we've also seen many changes in advance notice bylaws and how they affect activist investors, so we'll discuss the latest case in Delaware on these bylaw terms.
All right, let's, in this Delaware-themed podcast today, let's talk about the first subject, about what kind of environment it implies for Delaware. There's a number of things that have taken place in Delaware we can talk about today and in many future conversations. One specific case, recent case, stands out, and it's called Moelis, is how they title it in Delaware Chancery Court. Let's talk about it, and let's see how Delaware responded. Now, for everyone who does not know what Moelis is, what was that case about?
Okay, so you actually have to take a step back and start with a little background to understand the case, which is the corporation as a business form, it's very board-centric. Shareholders have very little formal power. They're supposed to elect the board, and the board runs the company. They do so usually by appointing a CEO, but then they oversee the CEO. So the board is the central decision maker. And to the extent there are any limits on board's authority to manage the company, those are supposed to be in the corporation's charter, which is its organizational document, kind of like the Constitution is for the United States.
I call those the bylaws.
Well, actually, the charter and the bylaws are different. The bylaws, as I explain to my students, the bylaws are the statutes. The charter is the Constitution,
cool.
Which means
Great.
It's harder to amend. You can only amend it with a shareholder vote, so it's pretty stable. So if you're going to limit board authority in some way, that's where it's supposed to go.
Cool.
But in recent years, starting in the private sector, in VC and private equity, really, they developed this practice of using private contracts, shareholder agreements, to give specific investors control over board decisions. So instead of putting a limit on board authority in the charter, the company would sign a personal contract with a particular investor, like VC, that says the board can't recommend a merger unless this shareholder approves. The board can't declare a dividend unless this shareholder approves, that kind of thing. So just to put it on the table, why is that a problem if a shareholder has a contract to control the board's actions? Because boards have fiduciary obligations to the shareholders. They're answerable to all the shareholders. And if they're controlled by someone who just has a contract, that means the remaining shareholders who have a proportionally greater stake in the company have less control over the board, and maybe decisions won't be made in their best interest.
So this is a fairly common habit or practice where some private party, some shareholder gets some extra rights.
Well,
as a result.
It's become so, and only relatively recently, in these VC and PE firms. It wasn't a really big deal before then. And then when this practice began to develop in the private space, these firms were actually warned that they may not be legal under Delaware law, these contracts, because board authority is supposed to be limited in the charter and not in these personal contracts. But the companies were private, so there really weren't any disputes about it, and the practice grew and grew until the companies started going public. And they
like
went
IPO public.
IPO public. And now you have
okay.
public shareholders. And the public shareholders have much more incentive than these private shareholders to actually challenge these agreements. And that's exactly what happened in Moelis. Ken Moelis took his company public. He was the founder, he was the chair and the CEO, and he also had a stockholder agreement in place that essentially required the board to run all major decisions through him first. The board had to seek his approval to take on new debt, to adopt a new line of business, to adopt a poison pill, to fire the top officers, to adopt a budget.
So he became, he had a lot of, he
was the
IPO'd,
board.
He sold his company to the public, to you and me, but still retained through this side agreement, this contract, not through the charter, through the contract, huge amounts of control that normally would be in the hands of the shareholders.
That's exactly right. In the hands of the board,
Okay.
anyway. So,
Or the board.
so it didn't really matter who you voted for the board. Ken Moelis was the guy who was in charge of the company at every level. So shareholders sued, and they argued you can't do that under Delaware law. If you want to limit board authority, it needs to be in the charter where it's stable, and it can't be amended without a shareholder agreement. And so that was the case.
So there was a lawsuit from some shareholder. They sued Moelis or the board or some group of people, and that lawsuit wound its way through Chancery Court, clearly in Delaware.
Exactly.
And when and what happened to that lawsuit?
What happened a couple months ago was the Chancery Court, Vice Chancellor Laster, agreed with the plaintiffs and said it doesn't matter. This contract is simply illegal under Delaware law. You cannot put board restrictions on board authority in these personal contracts. And that sent this huge shockwave through the business community for a couple of different reasons. First, because you have all of these companies with these shareholder agreements, some of which were private, some of which were public, and now suddenly like their entire governance arrangement was being held just sort of invalid at inception. So that was the first reason. But the second reason is there's this conceptual issue. Boards make contracts all the time, and those contracts restrict their ability to take future action. So, for example, it's really common for a board to agree to take on debt for the company and agree not to take on new debt as long as the old debt is outstanding, or to not sell their assets as long as the debt is outstanding. And activist shareholders, you would know, activist shareholders frequently settle their beefs with companies by getting the board to agree to include the activist nominees on the corporate proxy. And Laster was aware of all this when he wrote his opinion, and he didn't hold that all of these kinds of agreements would be invalid, but the lines he drew were sort of fuzzy and not necessarily precise, and that made a lot of people nervous about, well, what if maybe this one goes really far, but what about lesser contracts? Are they all going to be invalidated? And became concerned about whether they'd be able to tell whether anything was legal. And so this made a lot of businesses nervous.
So essentially, this increasingly widespread practice, I think Laster called it market practice.
He called it the market. He called it because when boards were protesting, they were saying, "Well, market practice has changed." It was actually it was a subtle dig because Laster, and I think he's right, held that the law as it existed in Delaware would not have permitted these agreements. And I think he's absolutely right about that. You can agree with that law or you can disagree with it, but he was correct as far as what the case law held.
So the couple things to conclude for the moment is that Laster voided this contract, said, Moelis, you can't have these rights. Mm-hmm. And that made a lot of VCs and a lot of other people who do business in Delaware a little nervous.
It made them extremely nervous.
Okay.
So
what happened?
Moelis is going to appeal, or it hasn't even filed appeal. But before that's even taken place, because that's going to take a while to resolve, there were proposed amendments to the Delaware Corporate Code. They were drafted extremely quickly to get them in before the legislature recessed for the summer. And the amendments would amend the statute, or did amend the statute, to say, actually, you don't have to put these restrictions on board authority in the charter. You can restrict board authority in a private contract. The contract can't go further than what the charter will allow. If there are some limits that you couldn't even put in a charter, then you can't put them in a contract. But beyond that, the statutory amendment said you can contract for things that otherwise would have to go into a charter. And in fact, these amendments, they were drafted so hastily that they immediately had to be revised to clean up some problems.
Oh, like typos and stuff.
No, actual substance. Like people saw them and they substantively were like, wait, you don't mean that, do you? So they went back and they changed them. But ultimately where they landed was you can have private contracts, you can have these private contracts with governance arrangements. They just can't go any further than what you could otherwise put in a charter. But it was all very controversial, partly because of how fast this was moving, and partially because these amendments really upend how we think about a corporation. Remember, the idea is that corporations are board-centric. It's fundamental to corporate theory. Everything else about corporate law flows from the idea that decisions are made by the board, not in these side agreements. So you had law professors protesting and writing letters, some lawyers who protested, Vice Chancellor Laster and Chancellor McCormick protested.
Wow. So two judges.
Yeah, two judges
who normally are just supposed to remain presumably a little neutral.
Well,
in this kind of stuff.
Not necessary. I mean, people criticize them for that, but the fact is there's a long history of Delaware judges weighing in on proposed legislation, so that's not fair. But yeah, they were concerned that these were too hasty hastily drafted, that they weren't well thought out. Nonetheless, the legislature passed them. So now boards are still subject to the fiduciary duties. They have a duty of loyalty and they have a duty of care. So they can enter these contracts, but if they do, they must take proper care, they must act in the best interest of the company and so forth. But unlike what Vice Chancellor Laster held, they are no longer categorically barred from signing away governance rights to a particular individual.
Okay, so the state of play is this case went down. Everyone got a little worried. Or everyone who cares got a little worried. And but the legislature stepped in. I mean, other than they made some mistakes along the way, did the legislature kind of know what they were doing here? Or who was usually when I see legislative stuff, there's someone behind it.
Yeah, and that would be the Delaware State Bar Association and the corporation, because Delaware has this very odd system where the legislature does not propose corporate law amendments. The state bar is tasked with, the Corporation Law Council is tasked with proposing amendments. And no, I actually don't think that the legislature understood it. I think they rubber stamped what the Corporation Law Council does because because some of the comments they had and questions they had just did not suggest a very deep, sophisticated understanding of these things. Okay. But the amendments passed anyway.
All right, so that's the law of the land, the law of the Delaware land, at least. Yeah. At this point, so this market practice of being able to bestow on a VC, an investor, one or another shareholder, all these extra rights, is now kind of returned to what it had been before, more or less before this case.
Well, no, I would say that the case was right as to what the law happened. But what happened was in these private companies, this practice developed, and that has now been ratified. But what was new, and the reason the case came up in the first place, was transferring these rights to public companies. That hadn't been done, and as soon as it was, that's when shareholders began to challenge it. So one thing to think about these amendments is sort of on a big picture societal level, these amendments make it much easier for single individuals to wield unchecked power over all the resources of the corporations. And for small corporations, maybe that's not a big deal. Maybe for private corporations, that's not a big deal. But for big public companies, it's a huge deal. I mean, imagine Elon Musk signing a shareholder agreement with Tesla.
Right. Is this going to make Musk have a little regret that he advocated to move the domicile of Tesla?
Well, see, here's the thing. This agreement would almost certainly be illegal in Texas, like it would be in every other state until these amendments. But I strongly suspect that what's going to happen is that other states are going to follow Delaware's lead. So right now, if Tesla had remained in Delaware, Musk would have been able to sign a shareholder agreement with Tesla that said, I get final power over how the board develops artificial intelligence. And he can't do that with Tesla as a Texas company because Texas would not permit these shareholder agreements. But I'm really expecting other states to start changing their law.
Well, other states tend to follow Delaware in many respects.
Exactly.
So, it stands to reason that they might start to, other states, my state, Illinois, though it's not a huge corporate domicile. New York is a biggie. California is a biggie. So they may start to adopt a similar, especially New York, which is home to, half of the VC community or the investment community. So.
I actually really expect Texas to do it because Texas is not only trying to lure business from Delaware, but I mean, there's a long history of states adopting their corporate law to benefit a favorite son. So I would actually be surprised if Tesla wasn't quietly talking to the Texas legislature to give them the same rights that they would have had if they'd stayed in Delaware.
Cool. Interesting. All right. And so does this kind of help? You've written a little bit about the overall environment in Delaware, and does this kind of help Delaware to gain favor again?
I think in the short term,
with the people who care about that stuff. Okay, go ahead.
In the short term, yes, but I think in the long term, it's actually pretty dangerous for them. So, short term, this is the benefit. One, obviously, a lot of VC and PE firms were very unhappy with Delaware and threatening to move out of state, and now they've been placated. Plus, Delaware sent a signal. And the signal is, we hear you, we respond to your concerns. So like Delaware made it clear that it will amend its law as necessary to keep corporations there. And all that makes Delaware an attractive place to do business, to incorporate a company. But here's the catch. When you put stuff in the charter, that's governed by Delaware law. That's why you incorporate in Delaware, because your charter is governed by Delaware law. These private contracts are not governed by Delaware law. They may not be governed by Delaware law. And you can put in them provisions that select that any disputes will be heard in other states and will be heard in private arbitration. So if governance moves into private contracts because of Delaware's changes and because other states follow, then it doesn't matter where you incorporate, because all the governance arrangements are going to be in these contracts, and you can pick a completely different state's law to govern your contract. So I think that this in some ways really hurts Delaware, because why bother incorporating in Delaware if you can incorporate anywhere else and choose some other state or some other forum in your private governance contracts.
So short term, they may have kind of shored up their reputation with the people who decide on domiciles, but long term, this may have some significant implications. Wow.
Exactly. Like, I think it weakens Delaware long term, especially if other states start following it, which I expect them to do.
That's interesting. All right, cool. Hey, we're going to take a quick break, and we will return momentarily to talk about advance notice bylaws here at Shareholder Primacy.
This is the Free Flow Media Podcast Network, where we cover the who of the business news, because investing isn't a what, it's a who. Check out our other podcast, Business Pants, for fact-based snark covering companies and executives, and the Proxy Countdown, the only podcast that treats company meetings like sporting events. Find them on iTunes, Spotify, or wherever you get your podcasts. Back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So now we're going to talk about advance notice bylaws. And Mike, what is an advance notice bylaw?
An advance notice bylaw. Earlier we were talking about bylaws. Advance notice bylaw is a particular set of terms in a company's bylaw. I like to refer to the bylaws as kind of the contract between the corporation and its shareholders. And that, these contracts address all sorts of stuff about how the board meets and, what the officers of the company are. Well, anyway, several years ago, companies started requiring shareholders to let them know, give them advance notice of a shareholder's intent to propose business at an annual meeting, or sometimes at a special meeting. So again, corporations meet once a year. That's the annual meeting where we do proxies and have coffee and vote on directors and so forth. And shareholders are allowed to make all sorts of proposals at annual meetings, in addition to asking questions and answers and shaking hands with the directors. Companies wanted to know, they wanted a warning if, like, an activist investor was planning on running competing candidates for the board of directors. They wanted plenty of notice.
Okay, so let's imagine it's a public company.
Yes.
If they're going to run an activist investor, if an activist investor is going to run their own slate of directors at the meeting, they have to file like proxy materials with the SEC, right? Why isn't that
correct.
Enough notice?
Because the companies wanted more. The companies wanted to know. So proxy materials tend to get filed like a month or two before the date of an announced meeting. Companies wanted, and basically state courts agreed that it was okay, companies wanted 4 or 5 or more months' notice that this was happening. So there's 2 dimensions to the advance notice bylaws. First is the actual time. So companies had plenty of time to understand and plan ahead and kind of get ahead of the activists and so forth. Second, the advance notice terms in the bylaws also included lots of information that the company requested or demanded from the shareholder about what they had planned. So it was kind of routine. And proxy materials that the SEC governs, required some of this. But companies layered on all sorts of other requirements about who the shareholder was and how many shares they own and what kind of business they're in and who they've talked to, and give us information about the nominees. So there was this whole long list of required information that the company had required from shareholders. So that was the basic of it. Go ahead.
So what do the companies do with this information? What's the purpose of it?
Well, presumably... that's a great question. Presumably, they're asking it on behalf of shareholders, that the company shareholders want to, the board thinks the company shareholders will want to know all this information about the activists, say, board nominees. Okay, realistically, companies mostly weaponize this information. they mostly pick through it and look for damaging or potentially suspicious elements about a shareholder's ownership, or if they own some derivatives or something, and they usually just try to use this information to kind of discredit an activist. I've said before that basically advance notice bylaws are really designed, presumably they're designed to help other shareholders, but they're really designed to make life hard for the activist. Okay. So that's kind of the underpinnings of it. And then there was a recent case that you also know about that kind of looked over this. Yeah, Kellner, and you could probably talk about that for a minute. But Kellner, an activist, which was not a well-known activist. It was kind of an individual. Encountered this company, Kellner, encountered this company, saying, "I want to run a proxy contest here." And what the company did is very quickly they imposed all sorts of other requirements. They added to their advance notice bylaw terms. They started requiring the activist to disclose who its backers were. They started requiring the activist to start making disclosures and arguably about its family members. All sorts of additional data. So the Kellner case challenged the advance notice bylaws, not because of the timing. They were still 4 or 5 months in advance, but because of the information content that the company, that AIM was the company, that the company was requiring. And so that kind of pissed off Kellner. Didn't want to start making these additional disclosures, and so they went and sued AIM in Chancery Court. We're back in Delaware, to kind of challenge these additional advance notice bylaws that AIM had adopted.
But the Kellner Group, they weren't like that great either, were they? I mean, they weren't.
Oh, no.
They were not saints in this.
No, right? No. Kellner. The Kellner shareholders, they had gotten someone who had a little bit of a securities law violation in their record to serve as a director candidate, and they were by no means kind of clean here. They weren't, they didn't have really high standing with the other AAM shareholders and so forth. So there were kind of two different parties. The activists didn't look great, and the company certainly didn't look great in all this process. And then so Delaware, they filed this case, and Delaware eventually made a ruling that we've both read that said that a lot of the additional information that AAM was requiring, in fact, was not legitimate. That wasn't allowed. And I remember you remember some of the things that.
It was just far too it was just far too complicated. There was one paragraph that apparently would take months to read if you sat down and tried to read it.
Exactly.
They were just far too complicated. And so it was really designed more to keep Kellner from challenging to the directors at all than it was to provide information to shareholders.
Exactly. So there's as activists, we've figured out how these advance notice bylaws kind of work. Okay, in addition to making us think months and months ahead of what we need to be doing, and trying to develop these volumes and volumes of information that, in our experience, very few other shareholders really care about. There's a couple of other elements to this that are worth mentioning. First, it's the advance notice bylaws are sufficiently detailed and arcane to somehow kind of put off or dissuade shareholders from even trying to comply. So once you see this long list of stuff you got to submit, and sometimes companies require you to fill out a questionnaire. There's all sorts of stuff they make you go through. You got to submit the data again 10 days before the date of the annual meeting, provide any kind of updates. One of the ideas is that these advance notice bylaws are so detailed and so so much of a hassle that we're not even going to bother. Well, that doesn't stop me in the past. It's not going to stop me in the future. However, the other point I want to make is that the advance notice bylaws are a way to kind of trip up an activist. That they're insufficient, and this is the paragraph. There was some, I can't remember. I think it was last year. I can't remember who the chancellor was.
Or was it for this case? It was Will, actually.
Oh, Will. Okay, Vice Chancellor Will had ruled on this and said, there's this 1,100 word paragraph that pertains to one bit of data and so forth. The idea there is that if you're an activist and you kind of mispunctuate something or forget something, okay, that the company is going to say, you didn't comply because of this technical violation, and it's within our rights to not let you resubmit this. Okay, so it's and friends of mine call it a foot fault or something. Little teeny mistakes. They're designed to almost make those inevitable.
Right.
Okay, and Will, I think, kind of recognized this in her reasoning on this, saying, you just can't, some of these are just so crazy that they're designed to make life hard for activists and or shareholders, and we want to do that. So so the outcome there, I think, was that most but not all of the additional terms that AAM imposed on Kellner were declared, I think, invalid.
Yes, at the chancery level, but then he appealed.
That was good, and you may want to talk about this for a second. So the company AAM appealed to the Delaware Supreme Court, and so this case was basically from last fall, I think, and kind of went through the court and so forth, and then it was appealed to the Delaware Supreme Court, which I think basically affirmed the chancellor's ruling. Is that correct?
Only in part. Actually, they agreed with. So she had found that some of the bylaws were enforceable and were reasonable, and some were not. Okay. But the Delaware Supreme Court actually concluded that, given all of the facts, which is that these new bylaws had dropped right when the activist had declared the campaign, and some of them were absolutely unreadable. The Delaware Supreme Court inferred from those two facts, essentially, that these bylaws were not intended to gather information to protect shareholders. Right. These bylaws were intended to prevent a proxy contest entirely, and that you're not allowed to do. You are allowed to gather information to protect shareholders, but you're not allowed to just cut off the contest. Right. And given that, the Delaware Supreme Court said none of these bylaws are enforceable, the entire set, because they were all infected by this bad motive. If they had been in good motive, but just overzealous, then the court could have said, well, this one's okay and this one's not okay. Right. But because they were all infected by this poisonous motive to begin with, they were all invalid. But the proxy contest by now is over, and Kellner had conducted himself so poorly because he submitted false information and whatever.
Oh, yeah, right. And there was
that the Delaware Supreme Court said, never mind.
Yeah, the Kellner activist project was not an exemplar of how activists should be handling themselves. In my, I mean, there was so
both sides did not cover themselves in glory.
No,
in other words, and given
exactly.
So the Delaware Supreme Court said, well, the bylaws are unenforceable, but also proxy contest is over, and we're not giving you any like the shareholder meeting's gone, it's over. We're not going to give you any relief.
Right, exactly. So normally Chancery could say, redo this.
Exactly.
Or your votes don't count. There's all sorts of remedies that the courts can order a company to follow, and basically, I think my sense is, to use layperson's language, Will kind of just washed her hands of this and said, "You people go away, get out of my courtroom."
She was willing. She trimmed the bad bylaws. She said the other ones are fine, and and Kellner did not comply and have submitted false information. Therefore, he doesn't get to run his candidates. And the Delaware Supreme Court said, well, actually, none of the bylaws are enforceable, but now that the proxy contest is over, Kellner, we dislike you so much that we're not going to do anything for you. So here we are.
So interestingly, I think, though, as much as we activists kind of grumble about Delaware, we have bad experiences with, books and records demands and all sorts of other stuff. This was actually pretty positive I mean, the activists I've talked to in my read of it is this was really kind of a positive development in terms of trying to deal with the worst of these advance notice bylaws. That the court, both at the Chancery level and at Supreme Court level, basically said, yeah, these advance notice bylaws can go too far.
Yeah. And certainly they gave you at least this much of a roadmap that is much better to just not comply and sue than it is to submit false information.
Yeah, yes, that's a very good point. So anyway, so that was Kellner. I mean, there'll be more of this to talk about in the as things ramp up for the end of this year and starting into 2025. But that was a very interesting and, like I said, pretty much of a positive development for activists in my estimation. So, all right.
Okay, so let's wrap up there. There's more we'll cover next time.
Yeah, thanks, Ann. It's been terrific talking about all this. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and also an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com, and you can find Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we'll talk again soon.